This is Radio 97. We are talking law with Despina Priala. And of course, Despina has a YouTube channel that you can watch any time of the day or night, any weekday that you like. If you want to catch up with something that's been on the program before, the 2 years, in fact, of talking law. In fact, it's more than that now. You can catch up with any previous program anytime you like just by going to the YouTube channel. And if you just type in Priala, Priala, and you'll find all of the previous programs there. Subscribe to that channel. Make sure you hit that button, hit the subscription button, and you will never miss out on any of the updates that you will find online there. Of course, Despina also with us each Thursday morning here on the radio.
And she's here again for chat number 2 coming up. For chat number 2, we just mentioned before the break, what if you're getting ready to settle on your dream home and then something terrible happens? There's a flood, there's a fire, there's some sort of damage. Can you get out of that contract, even if you're so close to settling? Despina, you have a bit of a story along with this particular chat.
I do, and I wanted to mention it this morning, and it was actually from a listener down, I think, at Brunswick Heads. It's Peter. Hi, Peter, if you're listening.
Hi, Peter.
Hi, Peter.
So Peter actually had a client who settled on a property down at Byron Bay near South Golden Beach, actually, last year. And that property went under contract in January. And then it got flooded. And I think people will remember in the Northern Rivers area, there were those massive floods in February, if I'm not mistaken. And this particular property was, when we say flooded, there was flood damage and water damage. And in the end, this particular buyer was forced to settle on the purchase of this property anyway. So she rang me and wanted just for me to look over the file and perhaps give her some advice about what had happened and whether it was right or wrong. And then it sort of occurred to me that perhaps other people in New South Wales are unaware of certain rights that they have in New South Wales, and when your property under contract is substantially damaged. So I thought we'd talk about that today and talk about some options and your rights under the legislation. So then you can take that away and unfortunately, if this happens to you, you can get some proper legal advice at the time. So in New South Wales, we have the Conveyancing Act. It's been around since 1919. And what that act says is that if you're under contract and possession, you haven't taken possession of the property, so you're still under contract, you haven't settled on the land, so the risk in that property is still with the vendor in New South Wales, then if your property or the land, it actually says, is substantially damaged, we want to talk about what that means in a minute, then there are 2 particular options or rights. You can have a potential right to rescind your contract, so to get out of that contract and get your deposit back, or what is called also you can abate the purchase price, meaning you can potentially negotiate a reduction in that purchase price, which for obvious reasons would then be based on the value of the damage and what would be required to rectify the damage to the property. So when we talk about, substantial damage to the land, and the definition of land includes buildings and improvements on the land, what are we talking about and what type of damage and how could it be caused? So I suppose the obvious, you've got natural disasters. So we talked before about flooding. So you could have flooding, you could have damage from fire, you could even have accidental damage. For example, strong winds might have caused a tree to fall on top of the property whilst you're under contract and cause substantial damage, or other types of damage. So every case will always be determined on its own facts. And what will be critical if this ever happens to you whilst you're under contract is you've got to get expert advice at the relevant time before you settle about, well, what does this damage mean? Is it permanent? Is it not? How can it be rectified and remedied, the cost? But I suppose the critical thing that comes out of that expert advice is it habitable? Is it livable? Or is it actually deemed that it's now just not livable, it's uninhabitable? And if that is the case, you definitely have a right to rescind, because obviously you can't live in it. And it's substantially materially changed from what you signed up for when you signed the contract. But in some cases, it won't be classed and you won't have a right to rescind where there's evidence that, look, yes, there's been damage, but it can be rectified. Yeah. Okay. Yeah. So
sorry, Despina.
That's right.
If it's purely cosmetic, you couldn't get out of it.
Well, let's talk about some cases, and that might give some perspective. So there was a case in New South Wales, 2007, and this will bring, some perspective to what the term substantial damage means. So it's a case of Backhouse and Fenor, and what happened there is that the house was damaged by fire. Okay, so you think, oh, fire, that's always pretty extreme, isn't it? In that case, the court found that the damage was not substantial and the buyer still had to settle. So what type of damage happened there? So there was smoke damage to the walls and the ceilings in the lounge room. The sunroom had sagged from water from, when the fire department came in and sort of sprayed water to get rid of the fire. So it had sagged, and there were carpets burnt and windows shattered. So to me, and I'm no expert,
That
sounds pretty serious.
Yeah,
exactly. But, there's always a but. There was advice from a structural and civil engineer at the time, an expert report. And in that expert report, it said that, well, yes, there's damage, it can be remedied, and it's actually habitable. It's actually livable still. Yeah.
Even though it had quite a deal of damage. If you walked into this house, you'd know that
you wouldn't want to live there. Yeah.
No, that's exactly right. So, as I said, it will come down to evidence. You've got to prove, not the vendor. It's up to you, the buyer. You've got to prove that there is substantial damage. You've got to put the vendor on notice. You've only got a certain time frame, so it's within 28 days of you becoming aware of the damage to then give the vendor this notice and say, hey, there's damage done to the property. We need to investigate this, and then definitely get reports out there, get costings, put it on the vendor to go and remedy. There's usually an insurance claim because the risk is with the vendor. So is the vendor lodging an insurance claim to get that damage rectified? So there's quite a few things to go through. Now, if the vendor doesn't agree that it's substantial damage, what can you do? So after going through those hoops, then you then might have to argue, well, you've got to reduce the purchase price, which is definitely a right, based on the value of the damage. But before you settle on that property, you want to make sure that damage has been correctly assessed. Because I think what happened with Peter's client is that there was a reduction in the price, but then ultimately the damage ended up being more than the agreed reduction. So before you settle, you want to get extensive quotes, understand the assessment of the damage, make sure it's been properly assessed by an expert, right? Like a civil engineer or structural engineer. And then everyone agree on that price reduction and then proceed. Yes, if you get a reduction at settlement, then that will happen if the vendor won't agree to rescind. But look, if you really believe that there is substantial damage and the vendor's just sitting there, saying, well, too bad, I don't agree with you, you can go to court. You can seek equitable relief from the court if you've got the evidence to prove it, because it's always costly to go to court. So you don't just do that at a whim.
And evidence obviously is the key here, isn't it? Because you talked about the engineer's report. So I mean, those things are not cheap either. So you've got to, but it's still quite obviously it's a huge decision everyone has to make when they're buying a house. But it sounds like you've got to go that extra mile in order to just prove your case, prove that
you do. And the other thing I want to mention is there was a recent case this year in New South Wales, and that case actually looked at this type of claim differently. And it looked at it on an objective basis. And that particular case said that the court determined that there was substantial damage, but it was based on pollution of land. And there was issues with asbestos and topsoil being used to fill the land. And that was considered, it was polluting the land, was contaminated. And that actually was classed as substantial damage, right? So that was sort of pushing the parameters a little bit outside of what the court normally looks at. So I think that was relevant and people can take that away and think about that in the future, particularly where if you're buying property and you're under contract for some time, you want to be careful of, for example, issues of potential illegal dumping of waste on land and things like that. So, which has been known to happen, as I understand, in the past. So you want to be careful about that. So yeah, as long as buyers are aware of these rights, they do exist in New South Wales, to get proper advice if this ever happens to you. And if you're in a contract under a long period of time, I would check that land regularly to make sure there's no issues with things like illegal dumping of waste and all sorts of nasty stuff that can happen.
Yeah, fingers crossed doesn't happen to you listening in. But if you do need advice at any point in time, you can you can contact Despina. Despina, if anyone wants to reach out, where can they go?
So you can phone the office 55 291 294, email info@prialalegal.com.au.
Thank you so much, Despina and Wayne.
And we'll see you next week.
See you then, guys.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.